response, if that's what's invited at this moment, is that in theory the statement or the email doesn't add anything, but actually I've got formal instructions to oppose it on grounds of 1, there's no application, 2, there's no actual evidence, and in any event it doesn't meet the Land Marshal test. So on the ordinary principles it shouldn't be admitted, and I don't think I need to say anything further. The only point we would add is that we say in essence it misstates our case in relation to 72 hours, but again we don't need to go there. And
it's a legal argument, is it?
Yes, Mr. Kovacs has addressed that in his note, so we'll have to reply to that.
Yes.
When he asserts that we've extensively changed our case, we'll have to reply to that. We probably need more than the notice that we've got this component.
Yes.
Well, my lord, we've looked at it. It reflects the email. It reflects what your lordship's anticipated. It really adds nothing at all. It's irrelevant to the issues. It therefore doesn't meet the Land Marshal test. Principle number 2, that it would have an important influence on the result, and obviously it doesn't meet 1 either. So, and we don't have a statement. So that's the position of the appellants. There really is nothing in it at all in my respectful submission.
Yes, thank you. Mr. Kovacs, is there anything further you want to say on the email?
Well, I appreciate this is highly unusual and highly unconventional, but it's equally unusual and unconventional for the bench to be told that something has nothing without seeing the material that's in issue. I think what I can do, and what I do now do, is to take on board that the court is not sympathetic to my request, but nevertheless to pursue my application for liberty to apply to adduce the witness statement along the lines of the email, in the full knowledge that I'm facing an uphill struggle for the courts to admit it. But, my lord, I think that is the appropriate course, rather than simply capitulate without the court having seen for itself the essence of the material in question.
Yes. Yes, just give us a minute to say that. Mr. Kovacs, there's no application to admit the email as evidence, and it would clearly be inappropriate for that to happen. So far as seeking to adduce evidence at this stage, which may or may not be based on part of the email, the view we have taken is that we would certainly not wish to encourage you to do so. We're not in a position, as we see it, to stop you making an application if you feel you must. But what we would say is that if you are to make an application to adduce further evidence in this case, dealing with the legal issues with which we're all familiar, and providing the evidence itself, it must be an application which is with us and with the other parties by 4 o'clock this afternoon.
Thank you.
And as I say, we're not encouraging you to do so. If you make such an application, we will initially consider it without the benefit of submissions from the other parties, and we will indicate whether we'll be able to do so late this afternoon or whether it will in fact drift into tomorrow, given other matters that each of us is dealing with at the end of today. I don't know, but we will indicate whether we need any assistance from the other parties or whether we are able to rule without.
Thank you.
All right. Now, I think, Miss Ree, you were going to complete your submissions on one or two of the specific cases.
Yes, thank you, my lord. My lord, it may be helpful if the court has to hand the judgment of Mr. Justice Friedman, which is tab 7 for the bundle
Yes.
medical justice. I've taken that out for convenience, and I also have open medical justice's submissions at page 25 of the same bundle, which are my own friend's submissions on the case studies, and I will cross-refer just to show that I'm dealing with the substance of what is set out in those sub-paragraphs. So, my lord, yesterday I was making some submissions by reference to headings, and I believe I addressed 3. I have 4 more headings to go on to by reference to the case studies and the evidence. So the next heading is the possibility to request an extension of the notice period, and that is something that Mr. Justice Friedman touched on in a number of places in his judgment. If I could ask the court first to turn out para 314 of his judgment. And if I could ask my lords to read para 314 and 315. And he's considering here the second witness statement of Miss Navarrete.
Yes.
So my lords will see that at the end of 314, Miss Navarrete mentions that in 8 out of the 14 cases, the period had expired by the time the clients were seen. Still, this means that 6 were able to be seen in the notice period, and of the remaining 8, my lord, over the page, the end of 315, Mr. Justice Friedman notes that no evidence was given about requests in respect of any of the individuals for extensions of time, or that any request had been refused. The other passage to highlight in 315 is that there is no evidence to the effect that by then, i.e. by the expiry of the notice period, it was too late and that nothing could be done for them. And Justice Friedman goes on to refer to evidence in relation to action taken during the window, and that meshes with the comments I was making yesterday in relation to numerous cases. I believe there were 7 of these case studies where legal action was taken in the window period. So paragraph 194 of the judgment, Mr. Justice Friedman again touches on the ability to seek an extension of the notice period. At 194 he does use the language of deferral, but he is in substance addressing the ability to seek an extension of the notice period, and he acknowledges and recognises that the policy states expressly that the opening of a removable window should normally be deferred if an unrepresented person wishes to obtain legal advice and cannot be, and then goes on to say that any refusal is amenable to judicial review. And so it's in the context of that comment that we say that Mr. Justice Friedman was entitled to come to the conclusion at paragraph 196 that by reference to the RLC tax and approach and the safeguards effectively within the policy, there is a structured exercise of discretion, and as a backstop one has of course the ability to judicially review any refusal. And my lord, the refusal must necessarily by definition come before the expiry of the 72-hour period, the notice period, if what is being asked for is an extension of that period. And so in my submission, the appropriate analogy here is to consider the opening of the window as analogous to the removal in a removal directions context. So just as the individual must hurry to make an application to challenge removal, in my submission the appropriate analogy when applied in this context is a challenge to the opening of the window or a refusal to extend the notice. And my Lord, it is consistent with my Lord Chief Justice observation in SB Afghanistan, and that is Core 25, which Mr. Kovats has just referred to, and it's paragraph 56, a different paragraph of my Lord's judgment, but that was simply on the basis of ordinary principles, and my Lord may recall that reference was made to an earlier case of Madan from 2007. My Lords may just wish to look at that paragraph, and that's Core 25, page 465, Core Authorities.
So which bundle?
Under 1.
Paragraph
56, my Lord. My Lord, we say, drawing on my Lord's observation there, that it is the opening of the window that is analogous to the removal in the removal directions context. And this is, again, precisely the point that the Tribunal made in FB. And if I could ask my Lord to look at FB Core Bundle, page 173. Paragraph 16.
Paragraph?
It's 167. And this begins by a description of a difficulty encountered by the firm Duncan Lewis when seeking to lodge claim forms directed at the window, and some confusion, initial confusion that was experienced. But the paragraph finishes, as will be evident, we regard that description as entirely accurate. Form Red 001 is a notice of removal. So we say that the notice of the removal window is effectively akin to the notice of removal directions.
Well, Mr. Kovats has made that submission.
Oh, I apologise.
Well, I mean, Ms. Reid, we do have to. We do have to understand that it's not appropriate for two counsel to be making the same submissions. I think we had understood your submissions would be on the facts.
Of course, my Lord.
Case studies.
That's an oversight on my part.
No, don't worry. But
so my next heading is in relation to the deferral cases, and that was a separate category of evidence considered by Justice Friedman. So these cases came to be identified via information provided in the Secretary of State's first disclosure response, and Mr. Justice Friedman records the data that was received in this respect at paragraph 177. And my Lord has been taken to this page already in the relevant annex. Of the 71 requests for extension of the notice period considered during the period from the 25th of May 2018 to 9th of March 13 were granted. And then from December 2018, it was possible to break these figures down by reason, and 15 requests related to access to legal advice, 10 were rejected. So, my Lord, if I could ask my Lords to look at Supplemental Bundle 1, page 698. So the relevant question, it is paragraph 11a, Roman numeral 1. And what is being sought are the number of requests to defer removal or extend the notice period. And so that is the question. So it covers both extensions of the notice period as well as deferral requests. And the data provided is at page 959 of the same bundle. And we'll also see that 79 requests were made, 13 were granted, and then the breakdown is provided. So of those granted, 4 related to access to legal
I'm sorry, which page? Which
advice.
is my fault.
I beg your pardon, it's page 959 of the same bundle, supplemental bundle.
Thank you.
So it's against this context that then we come to look at the deferral cases, and following on from this disclosure, the question was asked, well, what of the cases where the request was refused? And they form the DC cases that my Lord sees in the judgment of Mr. Justice Friedman. So the Secretary of State's response is at page 981 of this bundle. And under paragraph 2, you've asked for information and relevant documents in relation to the 19 cases where the request for the extension, it says extension of the notice period, but in fact this is meant to capture both categories, extension of the notice period as well as deferral requests. And each of the 19 cases have been reviewed. And the explanation is effectively given that instead of 19, it's actually in fact 11 cases because some of the cases were misidentified and 2 cases appeared as 2 entries each. So, and the other point to note in relation to this is in the text above that explanation, also, in a number of cases, there was no request for an extension received from the representative or individual, but the extension consideration was identified and completed by the Home Office caseworker. And so that is something that is then reflected in the table, Annex 2.1, which is referred to. And for that, my Lord, that is in Supplemental Bundle 2. Page 989. So I'm afraid
Page reference again.
it's 989, my Lord.
So this is the 19.
Yes, so this is the 19, but if by reference to the explanation provided in the Secretary of State's response, 11 and 12 are the same case, 13 and 14 are the same case, 18 and 19 shouldn't be there, nor should case 3. So by eliminating the cases identified, one gets to 11 cases, and the point that I was just making is reflected under the heading reason for a request in the middle of the table. There's an identification of where the request or consideration came from. My Lord will see in relation to case 1, 2, 3, 5, 7, 8, 9, 10, 11, 12, 13, 14, that they were all considerations identified by the caseworker and not by the individual or legal representative. So that is the position as set out in that table. So medical justice relies at subparagraph 5 of paragraph 39 of its skeleton on 6 particular cases, and my Lord may see from the footnote to subparagraph 5 a reference to the deferral cases, and these are the cases considered by Mr. Friedman at paragraph 180 to 185 of
What are we supposed to be looking at?
so
I'm sure it's my fault. I'm simply lost as to where we're going.
my Lord, I'm sorry, there is quite a bit of jumping around. If I could ask my Lord to turn up Justice Friedman's judgment at paragraph 180.
Yes, got that.
So this is the beginning of his consideration of the DC cases.
Yes, thank you.
And here he considers the particular cases on which medical justice relied below. And save for one exception, they are the same cases that are identified at footnote 25 to paragraph 39.5 of medical justice's skeleton. So, my Lord, it is helpful just to read his treatment in relation to each of those cases. So, firstly, DC1, my Lords will quickly see that this is an appeal rights exhausted individual who subsequently absconded, was later re-detained, and thereafter there was a flurry of late representations.
Well, would you like us to remind ourselves of the contents of paragraph 180 to 180? Where does it go? Right through to 191, doesn't it?
Yes, or 185.
185, okay.
Up to and including.
While we do that, can you tell me what we are going to get from, what proposition are we going to get from reading?
Well, my learned friend relies on these cases as instances where people were served with a refusal of a deferral request and immediately removed, or removed within a very short period thereafter. But if one sees the summary of these are cases where the individuals were appeal rights exhausted and were making late and often repetitive
Well, the judge
claims.
makes that point on a number of occasions in the paragraphs.
Yes, quite. So this is a particular type of case, and in my submission isn't representative of the entirety of the picture which my learned friend seeks to portray, namely that individuals are hit with refusal decisions and immediately removed. And it does go directly to the key concern that my learned friends both alighted on yesterday, namely refusal decisions, decisions on material decisions, which are then denied access to justice. And I think it is instructive to consider the nature of the decisions that were.
I thought we were under the heading deferral.
Yes.
But you're saying we're now looking at the history of these cases to show that.
Well, my Lord, I'm seeking to respond to the submission that the deferral cases here are instances where individuals are denied access to justice because they are removed so quickly after a a deferral request is refused. My submission is that when one considers the facts and context of each of these cases, there's nothing out of the ordinary in relation to that type of decision making. These are all cases where the individuals are appeal rights exhausted and have been for quite some time in many of the cases, and then there are late representations which are refused and removal is effected thereafter.
Yes. So I mean, we've seen that because that's what the facts of these cases are, and the legal submission which Mr. Kovacs made,
Yes.
and which we have, is that there isn't a denial of access to justice, because even if there isn't an opportunity before removal to go to court, there is after you've gone. I mean, that's the submission. So I think, I mean, we have read Mr. Justice Friedman's
Yes.
Judgment, and understand that these are a small number of cases, all of which have their own factual
Yes.
idiosyncrasies.
So perhaps then if I can just quickly move on to the timeline on removals in general, and there was data provided in relation to the average mean and median times between when representations are received in OSCE, when they're decided, and when the decision is served, and then removal. And my lords will see that at supplemental bundle 1 of the medical justice bundle. And it's page 972. So, my lord, I should perhaps start with the directing my lords to the caveat at the top of page 972. OSCE do not hold records which differentiate what type of removal notice has been provided to the returnee. However, the majority of returnees referred to OSCE in this particular year would have been served with a removal notice window. So, with that caveat, I would ask my lords to look at the table on the following page, and just above that table, of the 5,362 decisions, 50.2% were to maintain removal. So that means roughly half were to maintain and half were deferred, and that is a large proportion. 1.3% of decisions were made after the person's scheduled departure, and that is broken down to actual figures. So 68 decisions, in 22 cases, representations received after scheduled departure. For the remaining 46, the mean and median time is set out above. There was some discussion below as to which were the more relevant average, but in my submission it may well be the median that is most relevant to look at. So my lords will see that from receipt of referral to the decision, the median receipt to decision is 19 hours, and then from decision to removal it's 1 day, 4 hours, 35 minutes, and from receipt of the referral to removal, the median figure is 2 days, 10 hours and 45 minutes, and perhaps the addition of the mean figures shows the degree of variation that may be involved. So
we don't see the outer parameters.
No. But this is the best that OSCE could provide. But it's difficult to rely too heavily on these figures. However, it does indicate that the position may compare not unfavourably to the position where 72 hours notice of removal directions is given. If one sees that the overall time from receipt to removal is 2 days, 10 hours and 45 minutes. So that is some data against which the case studies in terms of removal should be set against. And then in relation to unlawful removals, well, I don't propose to turn up these in any particular detail, but just to give my lords some notes. There were 11 cases identified, and 3 of these were in fact the PLP cases, which were considered by the other tribunal and the High Court. And otherwise there were 8 further cases, and these were 8 cases identified over a 4-year period, 400,000 returns. And the passage that I alight on in Mr. Justice Friedman's judgment is paragraph 200, where he did identify a disconnect between the errors which led to the unlawful removals and the criticisms of the policy, and this goes back to the causal link point that I was seeking to make at the outset. So, before I sit down, I just want to make one further point in relation to the criticisms made in relation to Mr. Justice Friedman's treatment of the evidence. He says at paragraph 256 that these cases are about what might have happened, and that approach is criticised on the basis that it nonetheless ignores the risk that these cases display. In my submission, this displays a fundamental misunderstanding of the correct approach to systemic unlawfulness challenges. And there, in my submission, the approach is to consider first whether the policy is inherently unlawful, by reference to the way in which it's expressed. And if that is inconclusive, one then turns to look at statistics. And here, instances of actual breach can be indicators of a sufficiently high number of a systemic unlawfulness. But what Milena Friend is seeking to do is, rather than rely on instances of actual breaches, she's seeking to rely on instances of claimed risk of breaches. And in my submission, that's a dilution of the correct approach to systemic risk, systemic unlawfulness challenges. And there is a further danger in my submission when one starts adopting this line of thinking based on anecdotal case studies, and there is the possibility of divergent analyses which can creep in. So just by way of example, Medical Justice Skeleton at paragraph 39.3 identifies 4 cases where it said that the individual would have been removed if removal had not been cancelled for non-legal reasons. These are references to cases in Navarrete 1, and they are MN6, MN7, MN10 and MN11. If one follows the references.
6, 10 and 11.
Yes, 6, 7, 10 and 11. But in respect of 3 of those cases, 6, 7 and 10, Mr. Justice Friedman found that causation was not established between what had seemingly gone wrong and the policy. And for my Lord's note, this appears at paragraphs 128, 130 and 144 in respect of each of those 3 cases. And so in my submission, that's a further danger of proceeding on the basis of anecdotal evidence. And in any event, we say that those cases do not in fact establish the risk that Milena Friend contends. So those are effectively my submissions in relation to the data and the evidence, and unless there are any questions.
And that goes to the simple submission that individual failings don't necessarily demonstrate anything wrong with the policy that they're
Yes.
operating.
Yes.
That's the submission.
And so what one is left with are the unlawful removal cases, and that is, they are relatively few in number, and the question for my lords is whether that meets the relevant test as set out in the case law. And in my submission, just to complete our position on that point, the test has been variously expressed in the different cases, and in my submission the test in BF Eritrea is broadly in line with the test in the Northern Ireland case, in the sense that what is legally significant in the BF Eritrea case, given the statutory prohibition on the detention of children, was that more than a minimum number of children ended up being detained, and that was legally significant. I do accept that the test in respect of legislation is different for the reasons that Mr. Kovacs already explained. So if one applies that test, are these 8 instances legally significant? And in my submission, for a challenge of this kind, that is not an indicator of sufficient breach, and in any event, there's no indication that that wouldn't arise in relation to the ordinary removal direction approach.
Thank you.
Thank you.
Ms. Knight.
My lord, I had proposed to make some short points in reply. Obviously, if the application made by the Secretary of State is admitted by the court, then
Well, we appreciate that there would need to
There
be
may
all
be-
sorts of things that would follow.
yes. I mean, the other observation I would make, having now had an opportunity to read Mr. Kovacs' notes, is that he's asserting that the applicants, those applicants have changed their case, and that we're advancing a different case to that advanced below. First of all, I just observe that the case we're advancing is the case set out in our amended grounds of appeal. That's FB core, page 102. And three grounds, just absolutely clear that we say ground 1 that as the Secretary of State is obliged to serve a notice of removal following anaphoresa in the majority in anaphoresa. Ground 2, duty to notify within a reasonable period of time. That's paragraph 12 of the grounds. That's the alternative way in terms of the duty to notify within a reasonable period of time, the actual removal, to allow for the access to justice. And ground 3 is our denial of access to justice applying unison. That then goes into to deal with Miss Gilmore medical justice case. So our primary case is, as you can see from the skeleton argument, the concealment of the removal direction, the notice of the actual time and date, not necessarily the document itself, is antithetical to the rule of law. The Secretary of State is, which is consistent with Lord staying in the anaphoresa and the Kafkaesque scenario that he refers to there, that both myself and Miss Kilroy took to. The Secretary of State's case, as I understand it, on the section 10, is that the evolution of section 10, she says she never had a requirement to give you notice of your actual removal, unless it was an appealable decision. But these are all judicially reviewable decisions, so what she's actually suggesting, as I understand it, is incompatible with how the operation of the her obligations of the Refugee Convention and the Human Rights Act, unless it's saved by policy in the sort of BB sense that one saves incompatibility by looking at how the policy operates in practice, and then come to the application of the policy in context as it is here and say, well, it's unlawful because the person doesn't have notice of their actual removal. Just for the courts, so the substantive right, we say, the process of removal is the operative act of trespass to the person. That's why Lord Dyson referred to the anaphoresa principle in Lumber, paragraphs 34, 35, I took the court to those, and also 38, because that is if it's a lawful removal, that's the process by which the state interacts with the person, removes them from the territory, but until they are removed, they international obligations, the territorial applications still apply. So that's why we say it's a simple point, that there is no, it's antithetical to that concept where there's territorial obligations under the, certainly under Article 3 and the Refugee Convention, that there should be no notice of those. And we say the clearest possible statutory language would be required to interpret, if that was to be interpreted in that way. So similarly, when the Supreme Court was looking at the issue of out-of-country appeals and removals in the 94B context, again, just for the court's note at paragraph 36, what they said was, well, we note that this doesn't apply in cases where there's a real risk of serious irreversible harm. Parliament has sensibly said that's the case. And in any event, even when you're not dealing with such Article 3 type cases, you always, the question isn't limited to those, and you have to have access to the court in order to determine whether your remedy is effective. So that's, those principles are there, both in the context of protection and non-protection cases. I just wanted to make one more point, because I didn't take this case, it's in our skeleton argument, the reference of Mr. Justice Green as he then was in the Justice for Health case. So it's just for the court's notes,
Is this a
paragraph.
point of reply or another?
It's just, this is in relation to the need to.
Should you just give us the reference?
Yes, one of, it's paragraph 30 of our skeleton argument. Justice for Health, Volume 3, Tab 141. With the ability to challenge an adverse decision, which may include, as Mr. Justice Green identifies, may require the decision maker to be more specific as to when he will or will not act. So it's not just confined to being able to bring a challenge in terms of access to the court. It's actually about knowing when the act will take place, and that's why we say it's not simply limited. The notice principle, we say, is not simply limited to the Anna Frieda access to justice point. I think that's what Mr. Kovacs is submitting in his skeleton argument, or in his revised note. And so once it's accepted that removal directions are more than just merely administrative implementation, and that particularly in the context of the window being 3 months, where a variety of things might happen, you might either may be detained, but things may happen within that 3-month window, change of country guidance in the context of Afghanistan, this is Mr. FB potentially, or somebody who may not be fit to fly when the removal window is open, another example. There's a whole host of examples that can apply in that context. Or a person who's not detained, who then gets the letter, goes to 7-day notice, goes to report as they ordinarily do, are given a refusal decision and told they're being removed the same day. So that is antithetical to the rule of law point that Lord Stayne was emphasising on. So once it's accepted that there's a effectively always a two-stage process, because the removal is the operative act, then it's fundamental that you have notice of the date and time, and just so that you can react to it, and indeed make arrangements if one wants to go voluntarily or wants to be met at the airport or whatever it is. That's just a part of the human dignity point that we raise in our skeleton, which is very important in the context of what the Secretary of State is actually proposing. But more fundamentally, that so the individual can have access to the court if they require it. And in that way, we say the notice is required. So the current scenario that's being proposed, we say, is ultra vires. And if the court were to find that there was a parent of Section 10, then there's no convincing justification or proportionality in terms of that, in terms of the policy as it's currently operated. And I think just in terms of the final point I want to make is the Secretary of State is suggesting that an out-of-country remedy may be appropriate, and that one evaluates the question of fairness in that, in relation to the availability of such a remedy. So in SB, in my submission, the court, the passage of paragraph 55 and 56, just don't know if I need to turn it up, just for the court's note, identified that there needs to, whilst the basic principles are clear, there should be steps to challenge removal taken as early as possible. but the application to the court for interim relief should be made with as much notice as possible. That doesn't suggest that it's okay to rely on a remedy after the fact, unless for any particular set of circumstances, the Secretary of State might find that that's the evidence, as I understand it, that Mr. Pompa's evidence is going to. But that's not the scenario that we're ordinarily in. Once the Secretary of State accepts, as she does, that in some cases it's just too late to make representations, which she's not going to respond to, then we say that's where the policy falls down. That's where we say it is unlawful. There needs to be...
Sorry, I just need to understand that.
Yes.
I mean, you accept, presumably, that the time may come where it is too late to make representations.
My Lord, we say, as long as the person is still here, then we say that the representations that may be made and the Secretary of State will have to react to them. Mr. Pompa's evidence just goes to that very narrow point as to when, in fact...
Well, we're not concerned with Mr. Pompa's evidence, if you mean the potential new evidence. But I mean, one of the points of SB, I mean, the paragraphs you've referred to were in part dealing with a problem that was apparent from the materials before us, namely that applications were being made to the court, of which the Secretary of State could and should have been given notice, but wasn't. And the consequence was unfortunate in, leave aside SB, but more generally the consequence is that misunderstandings, shall we say, arise. But the second point is that, I mean, putting it in very practical terms, once the door is shut on an aeroplane and it's off from the stand and waiting to take off, as a matter of discretion, a court would not stop the plane. I mean, too late. And my Lord's point from yesterday, if an hour and a half before the plane is due to take off, 300 pages arrives by attached as an email to OSCE, it would not be unlawful for the Secretary of State simply to say, I'm sorry, I can't even read it, let alone make a decision.
Well, what we say in those scenarios is it may not be, but the policy is aimed at something rather different.
Yes, I think I understand.
And as my Lord Chief Justice noted in SB at paragraph 80, if there was a real risk identified within the documentation, then there would have to be some relief available. Just the final, sorry, I said it was the final point and now I realise it's not the final point, just one more point. Sorry to take up the court's time.
No, please don't.
Just in relation to Miss Reeve's point, I think, and also Mr. Kovacs's point about what's the test for systemic unfairness. Just want to give the court the note of the reference in the case of W. Which is at paragraph 59. Core bundle, tab 28.
So authorities 1, I think.
Authorities 1,
yeah.
core bundle, Justice Bean and
Yeah.
Justice Chamberlain. And the test is, does the regime read as a whole give rise to a real risk of unlawful outcomes in more than a minimal number of cases? So this is when you're talking, as my Lord Justice Hickinbottom indicated, about looking at it from this, before the, rather than having to examine everything after the fact, after people have been removed, is there a real risk of unlawful removal? And then paragraph 66, again, of that judgment, dealing with how the inherent risk is identified and how it's applied in practice. The policy there is found to has the potential to mislead patients in a critical respect and give rise to real risk of unlawful decision making, and the significance is certainly more than a minimal number of cases, and that's again the test that we suggest to say here. So I'm sure Ms. Kilroy will respond to those points, but we say that the case studies that are available and the evidence that is available both illustrate the problems that arise from this policy, not don't demonstrate a statistical case. And so, and just the final, just in response to the BF point and the points that Mr. Kovacs raises about remedy, he's suggesting that somehow there's a justification for interference where you can have damages for unlawful detention in the BF Eritrea case, damages for arrest in the or some other kind of remedy, where the action has been unlawful, but that conflicts, we say, that interpretation conflicts with the way in which the international obligations and the principles, both common law and under the Refugee Convention in Article 3, ECHR and Article 13, the procedural obligations there are absolutely clear and it can't be dealt with by remedy after the fact. My Lord, unless I can assist you further.
No, thank you very much indeed, Ms. Knight. Yes, Ms. Kilroy.
My Lords, can I first address the allegation that medical justice has changed its case? The case of medical justice is set out in the grounds of claim, the original grounds of 350 to 387 of the bundle. And what your Lordships will see, if you look at that pleading, is that it hasn't changed at all. The Secretary of State, on the other hand, has changed her case frequently, including by originally accepting that there was an impediment, as I showed you, on the right of access to justice, and now apparently arguing for the first time already yesterday and enshrined in this note handed up this morning, that access to justice can be met after the event when something has been removed, which is an entirely new argument. So I don't accept the allegation. Can I address the argument that putting you on a plane out of the jurisdiction is not an impediment to access to the court because it's not a legal impediment? Now, I'm afraid I just don't understand that argument. I don't understand what it means. But in any event, nothing whatsoever in the authorities that we've seen restricts the notion of impediment to any particular type. And since the common law is setting out...
Sorry, could you just, notion of impediment to any particular
type. Of impediment.
Sorry, I thought you said flight, and I was thinking
apologise.
that couldn't be right, so... particular type, yeah.
Particular type. It simply says unimpeded right of access to court. And that word has got to be understood in its, to have its ordinary meaning. There is no suggestion anywhere in the hundreds of years of authorities that that includes, is limited to an impediment of a particular type. And since the common law is setting out a core principle of the right of access to court, it would be extraordinary, in my respectful submission, if certain impediments were permitted, but not others. The authorities that I have asked your Lordships to look at, and some of those that we didn't look at, indicate a wide variety of impediments, stopping correspondence in Raymond and Honey, and impediments by imposing requirements, such as fees and permissions in Witham and Unison, and impediments by not telling you about things, which is anaphragable. The source of these impediments, furthermore, is varied: rules, secondary legislation, and so on. But it cannot surely be the case, if that is the argument that's being made here, that an impediment is all right if it's in a policy, but not in regulations, if that is the argument that's being made. Yes. But in any event, whatever the argument on whether there needs to be a legal impediment, medical justice disposes of it. Because in medical justice, which was upheld by the Court of Appeal, exactly the very same impediment that we have here, was held to be a breach of the right of access to the court. In other words, not enough notice of your removal and then being put out of the jurisdiction. And in my respectful submission, that disposes of that point. Medical justice, which is at tab 19, tab 20 of the Court of Appeal upholding the judgment, also disposes of the argument that the access to justice principle can be satisfied at common law by allowing you to bring the challenge once removed. The remedy that is sought in a claim of this type is to prevent removal. That is the remedy that is sought. And after the fact, remedy is not the same. And so preventing you from, in advance, preventing your removal, or inhibiting you from in advance, preventing your removal, does not meet the principle. But in any event, as my Lords observed in the course of my learned friend's submission, in this particular context, that removal may have irreversible effects. So that a claim after the event may be nugatory. The most severe of these irreversible effects is, of course, torture, imprisonment, or death. And so the analogy with arrest in this jurisdiction is imperfect indeed, in my respectful submission. But the effects also include not being able to bring the claim at all for more pragmatic reasons, and those were explored in Chiari, with statistics indicating the very large number of appeals that were dropped as soon as the person, or were not brought, as soon as the person was out of jurisdiction for reasons of difficulty in accessing legal advice, and so on. And that difficulty is reflected in the judgment in medical justice at paragraph 34, and I won't ask you to turn it up, page 295, the difficulties in bringing claims out of the jurisdiction. Now, of course, that possibility of irreversible effects underlines the Article 3 and Dublin 3 case law. Although in the case of the latter, the removal, since the removal is to the European Union, in some cases the irreversible quality of that is muted. But even so, there is, as we saw yesterday, a right to ask the court in advance of removal for that to be suspended. And so if my learned friend's arguments were accepted in relation to the common law, the policy would still be unlawful under Article 3 and Dublin 3, and he did not have an answer to that question when put to him. Now, in my respectful submission, it would be a sorry day if the common law right of access to justice provided less protection than Article 3 of the European Convention and EU law, and in my submission it is obviously not correct.
Well, the common law created the whole concept.
Yes, precisely. My Lord, can I turn now to the argument that somehow this policy puts people in no worse a position than if they got 72 hours of their removal directions, notice of their removal directions. Now, my Lord, that submission elides two possible factual scenarios. The first is the position that pertained before this policy was introduced and is current now, which is that you get 72 hours at the end of the process when you've had your liability to removal some time before, you've responded to your Section 120 notice, you've had a decision on those representations, and then removal directions are set. Now, my Lord, this process and the idea that 72 hours, when served with that earlier liability to removal, accompanied by a Section 120 notice, is the same as when it's served later, is obviously false, as a matter of fact. Much more needs to be done. That's the whole basis on which the Secretary of State decided to bring the notice period forward. That's what her evidence says. That's what the policy equality statement says. Bring the notice period forward to enable representations to be made. But if the argument is that it provides no less protection than serving removal directions at the same time as a notice of liability and with the Section 120 notice, then I agree. But that only serves to emphasise how unlawful this policy is. Just imagine if that is what in fact they were doing now, which they're not. Serving removal directions at the same time, immediately you encounter someone for the first time, you give them a notice under Section 120 of the Act, you ask them to make representations, which you say you will consider, but you then put them on a plane before you've had a chance to consider them, for example, or you give them a notice period which you know is wholly inadequate to complete all those tasks. So in my respectful submission, when properly understood, the staging of the service of this notice is at the heart of why this policy is so unlawful. It's because it's served alongside notices requiring a response from the individual and then decisions from the decision maker. And you can see what the original 72-hour period was intended to do. One thing and one thing only, and I referred to it in summary, it's summarised in the detailed grounds of claim, but if I could give you the references, in FB Supplementary 1, A1 to 5, and
I'm sorry, 125.
A1,
How do you spell 2?
pages 1 to page 5.
Oh, sorry, yes.
A page 1 to page 5 is the first letter, and A page 6 to page 11 is the second letter. And these are letters from Lynn Homer to ILPA, which I referred to yesterday, explaining the thinking behind the 72 hours policy. It's all about lodging a judicial review. That's it. That is all that is anticipated will occur
So
at that stage.
this is the 72 hours notice of
Removal directions. It was never anticipated that that period would include responding to a section 120 notice and decisions then being taken on it, because that process would already, that boat should at least already have sailed. So what is different about this is the bringing forward, and that is why the period makes no sense at all, and why it is resulting in decisions being taken in the window. That's the factual position. My Lord, the Secretary of State said yesterday that the only cases in which unlawful removals had taken place, or were not Article 3 cases, or there weren't many examples of Article 3 cases where unlawful removals had taken place. That's just not true, in my respectful submission. MLF, which is one of the examples I took you to yesterday, was a Sri Lankan asylum persecution case. It was an article, and therefore also an Article 3 case. In A, which I also took you to yesterday, the deception case, he is relying on Article 3 medical reasons. In some of the improper removal cases, which are the summaries of which are in supplementary bundle 28 to 35.
This is your supplementary
Our
bundle.
supplementary bundle 128 to 35. These improper removals or returns cases were asylum cases. So it's just not correct that those are the only examples. But perhaps more importantly of all, what both Ms. Wee and Mr. Kovacs have repeatedly suggested that the numbers are so small that they're insignificant, but without reminding the court of what the Secretary of State herself told us about the monitoring of this policy, and that is in a letter at Supplementary Bundle 1, 705 to 714. And to cut a long story short, they've never monitored the effect of this policy, and the cases that they identified in response to our questions, they identified only by having to ask individuals and essentially rely on what they called as corporate memory. And it came with the caveat, and you can see this at pages 710 and 713, it came with the caveat, these cases do not purport to be exhaustive. Now, in circumstances where the Secretary of State, who has the sole access to information about what is actually happening on the ground, is not monitoring, not keeping records, and is unable to give a proper assessment of how many people have actually been unlawfully removed, to then suggest that the figures that we've got, the anecdotal evidence, is a point against the appellants, is in my respectful submission without any foundation. My Lords, on the test, we say that we meet it whichever way you look at it with this policy. The policy is on its face unlawful before you even get into risk. Now, if one looks back at the cases, the prison cases, for example, Anderson, Leach, Daly, Sims, no one asked whether there was a risk because the policy itself permitted a step which was in conflict with the right of access to justice. When that happens, the policy is just unlawful on its face. And that is what our primary case about this policy is. It is inherently unlawful in its terms because it permits something which is contrary to the common law. In other words, removal without an opportunity to challenge a material decision. But we also say we meet the unacceptable risk test. There are examples showing risk, which we say is relevant. Risk of removal, because it shows that people do get into the window. and decisions are being taken at a time when they could have been removed. Those are the cases where, in fact, a denial of access to justice was averted at the last minute, but they were at risk, and we say that is legally relevant. It obviously is legally relevant because it shows that the risk created by the policy is not theoretical but real. But we also have examples of cases where access to justice has in fact been denied. Now, in this context, where the consequences are so potentially grave, what is an unacceptable risk has to be measured against that. And in my respectful submission, an unacceptable risk in this context is a risk. You only need one or two cases to show an unacceptable risk in this context, in my respectful submission, and that was the point that was accepted in medical justice, number 1, tab 19, where the court said, at paragraph 41, it is unnecessary for the claimants to show that by applying the 2010 exceptions, the right of access to justice has actually been infringed. But insofar as there are any cases where this has occurred, the task for the Secretary of State might then become the more difficult one of showing that there is no serious possibility or unacceptable risk of the infringement of the right of access to justice. That, in my respectful submission, is the correct approach in this context. We have examples of where the inherent risk in the policy has resulted in denial. The Secretary of State has not produced any evidence at all to show that that is not a serious risk. In fact, she's produced hardly any evidence in this case. Now, my lords, on that question of evidence, I do wish to highlight at this point, in relation to this application that has been made this morning, that the appellant has repeatedly, throughout these proceedings, asked the Secretary of State to explain how her policy works. And what we have had in return is a deluge of material from which we have had to derive an assessment of how it works in practice, with no witness statement addressing it and addressing the potential risks and how they are met. So for the Secretary of State to arrive this morning and start trying to produce evidence on a particular area of application of the policy against that backdrop is, in my submission, it's a very unattractive stance. And I do refer here to Citizens UK, the duty of candour aspect of that judgment, of paragraphs 105 to 106. The responsibility on the Secretary of State, when complying with the duty of candour, is to produce a statement explaining and addressing the relevant issues in the case, not just a mass of disclosure.
Could I have the paragraph numbers in Citizens UK?
It's 105 to 106. It should not be necessary to have to leaf through hundreds and hundreds of pages in order to work out how this policy actually works and how it's applied. And despite those repeated requests, we've had virtually nothing in terms of evidence. And on I said yesterday that I would give you the references for the table of propositions and evidence, which is the claimant's evidence, because there is a lot of evidence from the claimant, and I didn't. It was SB 162 to 75, I believe.
So that's the table.
It's a table of
That's how we
propositions
receive
and evidence, and what it does is it also has cross-references to all the various statements. So if my lords want to look at the underlying witness evidence, you'll be able to find them in the bundle. By contrast, the Secretary of State's evidence consists of one witness statement that was served at the time of the interim injunction and two witness statements that were served in the course of proceedings directed only to duty of candour problems. No other evidence in this case. There's one statement, very short, in the FB proceedings which doesn't explain how the policy is applied in practice. So I do say that there has been a failure to comply with the duty of candour in this case. My lord, on the submissions that were made by Ms Ree yesterday and this morning. My Lords, there is a lot that could be said in response to some of the points that she's made, but essentially the medical justice's case about the evidence of examples and why the judge got it wrong is that he didn't understand the function of those examples that were given. They were there to show the risk created by the brevity of the notice period, the difficulties of obtaining access to lawyers in that notice period, the risk that material decisions would be taken in the window, and the risk that people would be removed. But what Ms Ree and the judge, echoing the judge's approach, did is to look at whether there were mitigating factors or other reasons why this person in the end could have obtained access to justice earlier, or, for example, was it a caseworker error, and so on and so forth. Well, my Lord, that is not an answer to the evidential threshold that a medical justice has, in my respectful submission, crossed, which is of showing that there is a serious problem with this policy. And there are a couple of more nitty-gritty points that I want to make, and then I can stop, and I will stop, that you are keen to finish it when possible.
We have plenty of time to hear whatever submissions you want to make. Don't feel under any pressure.
Well, thank you very much, my Lord. I appreciate that. So one of the points that is made is that in relation to the, and it's made by the judge, so it's important that I address it, in relation to the evidence of Miss Navarrete, but also some of the deferral cases, what is said is there's not an explanation, or there's an absence of explanation about the access to lawyers before the notice period began. But, my Lord, the problem with that point, as far as the Secretary of State is concerned, is that access to lawyers before the notice period began is not the basis on which that notice period has been designed. Nobody, and there's nothing in the policy which says we're going to give this notice to people who have already had access to lawyers. And indeed we see that it's served on people at the point that they are first encountered, when there is no evidence at all in the Secretary of State's possession often that they may or may not have had access to lawyers. So what's happened before is not relevant to the question of whether the notice period is adequate. It's been selected, and we see it's the origins of that selection in Lynn Homer's letters, references to which I've given you. It's been selected presumably on the basis that it is sufficient for the tasks that need to be carried out in the period. So in fact, the possibility that some of the examples advanced by Ms Navarrete and also in the disclosure that those individuals may have had prior access to lawyers works against the Secretary of State, because what it shows is even where individuals have had prior access to legal representatives, they still can't get everything done in the notice period. So again, this highlights the mismatch between the way in which the judge approached it and the way in which these examples were advanced, which was to show problems with the notice period rather than illustrate that there has been a denial of access of justice in those individual cases. Problems with the notice period, problems with the policy. My Lords, one of the examples, just for your note, is a deferral case, and it highlights something that Mr. Kovac said yesterday. It's called DC, it's often called DC1, it's at Core Bundle 16, where there is a table with dates. Now this was
DC1.
DC1. You can also see him described in the first line of the cumulative table at CB12. Actually, I think it's SB16, not CB. So
Yes, that's
supplementary
what it is.
bundle 1, page 16. Sorry for my acronyms.
Sorry.
And there is an updated one, I apologise, at 116. This one was updated after information received from the Secretary of State. So it's 116 that my Lord should look at, I apologise. And what that example illustrates a couple of things that the court looked at yesterday. This was someone who did not have legal representation. He had been appeals rights exhausted some years before, in around 2011. He was picked up in a cannabis farm and he comes from Albania. So there were obvious indicators of possible trafficking. He tried to make a set of fresh representations. You'll see that they all happened at the weekend. He didn't have lawyers. They were made and rejected at the weekend. One of the reasons they were rejected is because they contained untranslated documents. Of course, he wasn't represented. It was impossible for him to provide translations. He makes a second set of representations on the Monday, bearing in mind, of course, that he doesn't know when his removal is. The Secretary of State does, but he doesn't. They are refused the same day, but it's not clear when service is affected of those removals. And he is removed at 7:45 in the morning, in other words, before the court opens in non-office hours. And that's relevant in a number of ways. The obvious impossibility of this person without legal representation properly putting in submissions that would make sense, untranslated. The reliance of the Secretary of State nonetheless on the fact that documents are untranslated, a refusal of a deferral, and a complete barrier to access to justice for this individual. Now, whether or not he had a good claim, or whether or not he should have got legal representation earlier, is not the issue, and that's not why we're relying on these examples. It's access to justice with an independent arbitration of whether the Secretary of State's views are lawful or not.
But there's no evidence as to what happened after his removal.
No. This material all comes from the Secretary of State. So the material that, what we know about it is what the Secretary of State has told us.
No, I understand that, but we don't know.
We assume that that's the end of it for him,
No, I see that.
and we don't know.
So the judge dealt with that at paragraph 180.
Yes.
Because just as you're doing now before us, before the judge, you said that was a clear illustration
Yes.
of the inadequacy of the safeguard of the power and extension of practice. The judge makes the point about submissions not being within the notice period. And really, the point is not on the factual findings, but the judge's conclusion that it didn't establish a removal without effective access to justice. You say it does.
Well, yes, because the judge is...
I mean, that's the point of difference. It's not
It is the point of difference.
We've looked at a number of these, the supporting factual documents, but it's the conclusions you draw from it rather than the underlying facts themselves.
I'm very grateful because that is exactly it. It's a difference of approach. The judge says, well, overall, it's not clear whether this person has had access to justice or not. They may have done, because I'm looking at it in a holistic sense. And I mean, some of the judge's conclusions and the way in which he's approached it are unclear, which is why I showed you paragraphs 193 and 196. Because on the one hand, he says it's lawful because they can have a right of access to judicial review, and on the other hand, he clearly knows that these individuals did not. So that's the problem with the judgment, in my respectful submission. It's not actually clear what he in fact thought and why he in fact thought this policy was lawful. If he thought judicial review was available, it plainly wasn't. But insofar as he's looking at what happened in this individual case, he appears to be saying, well, I'm going to take into account the possibility that there were previous opportunities to access justice and this person hasn't availed themselves of it, or he draws inferences that the case was without merit. But with respect to him, that is not the point. The point is that the only person who was able to make that judgment was the Secretary of State. And that is not, in my respectful submission, in compliance with the law. My Lord, I'm just checking through to see if there's anything else I need to say. My Lord, there was just on the Chiari point, my learned friend, Miss Knight, has mentioned Chiari in her reply this morning, but of course the court will remember, and I asked your Lordships to look at the paragraphs over the night of Tuesday night. But what the court said there is that you must punctiliously supervise a decision by someone who is an opponent or a defendant in an appeal to put their opponent out of jurisdiction. That's what the court said then, and that's precisely the problem here, is no one is supervising it at all. And that's in an Article 8 case. That's paragraph 56, I'm sorry, I didn't give you the reference. Paragraphs 56 punctiliously supervise the court must when someone decides to put their opponent out of the jurisdiction. Now, my Lord, this is another final point about Miss Navarrette's evidence, which is that Miss Navarrette, what is said is that she doesn't explain why she saw some of these people outside the notice period. But of course, the evidence as a whole explains why that happens, which is that there is difficulty in accessing the detained duty advice scheme in these detention centres, and you have the references for those waiting times.
We saw a chart, yes.
A chart.
Yes.
So the evidence does show why people have difficulty accessing that scheme. And I said it again, like Miss Knight, I said final, there is one other point on statistics. Miss Reid took you to some statistics on OSCE decision making, and I just want to record, make sure that the court is aware, OSCE only gets the representations when removal is imminent. So what it doesn't tell you, and of course the only person who knows whether removal is imminent in a window is the Secretary of State. That's important to remember at all times. But the individual, once in the window, does not know whether removal is within 1 day, 2 days, 5 days, 3 weeks. So what you don't see from those figures is the period of time between representations that are lodged, let's say on day 10 of the window, when the removal directions are not until some time later, and the Secretary of State herself delays in serving decisions until close before the removal itself. It's just important to bear in mind that that's what those figures they
So
are.
the short point is that they're only a small part of the cases that might be throwing up difficulty.
Yes, in the window, yes. Well, they give the impression that everyone is making their representations right before removal, whereas that's not correct, because OSCE only gets them when that happens. May I just?
Of course.
My Lord, the references for that evidence is paragraph 3 of Mr. Pompey's statement at page 643. This is on OSCE only getting those, only getting those representations at that point.
Sorry, again, paragraph.
Paragraph 3, page 643 of the core bundle, supplementary bundle 1, sorry, and then supplementary bundle 1, page 895, at answer 2D. And my lord, on the table of propositions and evidence, my learned junior just wanted to check that you had got the updated references, because we replaced them in the bundle probably about a week or so ago. The earlier version had references to the medical justice bundles below, so it's SB 162. Could I just ask you
Let's just have a quick look at that.
to check? If the first reference you have is SB1.
My hole punching is wobbly, which means I did it myself, so that must mean it's the later version.
It should say, just to check it, SB124 should be the first reference.
This is page 62.
62 of SB1.
I'm sorry, the first reference where?
In the table, there should be a table, and the first entry, number 1, if you go across to evidence and reference,
Yes.
it should say McCloof, para 19, SB124.
Mine doesn't. Mine says G189.
We have copies of the updated table.
Mine does.
Yes, mine doesn't either. So if my lord and I could have.
Oh, two.
It says at the top, referencing to Court of Appeal hearing bundles has been inserted in place of the original.
So if we get rid of the original.
Yes, you can get rid of the original.
Yes, that's kind. Good. Well, thank you for giving us those. Certainly help. Good.
Could I just raise this one tiny point, and it doesn't have to be dealt with now, nor by you, because I asked this of Mr. Kovacs, and it doesn't matter that he hasn't responded, but in the judgment of Mr. Justice Friedman, in paragraphs 27 and 28, he refers to a Home Office policy equality statement and sets out quotes. Now the first quote, which is in paragraph 27, we know where that comes from because Mr. Kovacs read it out, and that's the statement in respect of the policy. But I couldn't find where the quote in paragraph 28 came from.
It's an early version of it. It's at page 953 of
953.
of Supplementary Bundle 1.
That's excellent. Thank you very
And
much.
this is the 2013 version of the Policy Equality Statement.
I've got it. Thank you.
953 to 957. With thanks to Miss Pickup.
Well, I've just had some instructions in response to the respondent's note, and I wonder what I may just put those in writing in short form.
Are you able to do it
Yes,
today?
Absolutely today.
Would help us if you could.
There's one specific point, which is in relation to paragraph 3.1 of that note, which says that the section 10 notice is only served after the caseworker has checked there are no outstanding representations, applications or appeals. And that is in conflict with the way it is expressed in the arranging removals policy, which specifically means a claim that's been determined to be accepted by the Secretary of State. The wording outstanding representations isn't there. It is pending application, appeal or administrative review. So critically not the scenario that we are in.
Well, is that why don't we just make a note of that submission?
I was going to, in fact I overlooked it. Both 1 and 2 are wrong, in fact. 3.1 and 3.2.
Could you give me the reference again?
So the reference in the arranging removals bundle is Medical Justice Core Bundle 512.
So core bundle 1, that may, yes, and 512.
And also at 399. Oh yes, sorry, got it. And 399, which is in
Sorry, 512.
512 is arranging removals.
Yes.
And 399,
Is
which is the action policy, which is version 17 of the JRI. And it
so
says
that's
it's
the
not
policy at
yeah,
core bundle page
399.
399.
Yeah, which is version 17, where a person has no leave. This is where those not suitable for the removal window. A person has no leave that has made a protection or human rights claim or appeal pending. But that claim is only a claim once the Secretary of State has accepted it as a claim. So back to the 353 point. And so that's why we say that if you have had outstanding representations and consistent with Miss Kilroy's submissions, that you could still be served with a notice of removal window, even if you've already made those submissions. So it's not just for people who make submissions in the window, in the notice period.
So that goes to point 1,
Yes.
and then point 2, Ms Kilroy was submitting was error. So removal directions are set only if there are no outstanding representations, applications or
We don't.
appeals.
I mean, first of all, we don't accept that. But secondly, in any event, we wouldn't know about it because by the virtue of the policy, you wouldn't have such notice. But paragraph 3.1 is what's repeated at paragraph 12 of the Secretary of State's skeleton argument. It goes to the core of the scenario that FB and others bringing protection claims in particular, but other claims as well, goes to the core of our case, which is why when we got this note this morning, it does go to the core of our case. And if it's being suggested in any way that we change, that either what the representative...
Well, I think, Ms Knight, you're
yeah, so we need to...
going
we just
back
like to
over
respond.
old ground.
We'd like to just respond very formally, very shortly and succinctly today in writing so that there's no doubt about
Yes,
what the
all right.
Secretary of State's policy says and what our case is.
All right.
Thank you.
Ms Kilroy, anything on that?
No, I was just going to say in relation to 2, what we don't accept that, we accept that the policy is that you shouldn't be removed pursuant to removal directions if there are outstanding representations. We don't accept that there's any evidence that they're not set. And of course, as Ms Knight says, since one doesn't know when one's removal directions are, the problem is that you can be removed in breach of that policy. And there are examples of that happening.
So it's 2 different points. In
Yes.
relation to point 1, you say it's wrong.
Yes.
In relation to point 2, you say you don't know whether it's right or wrong because you don't get the removal directions.
Yes.
Yeah.
And it's not, it doesn't say that in the policy.
Yes. All right. Well, if
Yes, and in fact the policy says the opposite. At 454, and Ms Pickup points out, while it's lawful to detain, this is in core bundle 454, tab 18. While it's lawful to detain and set removal directions before further submissions are considered. Further submissions are usually considered before service of RDs in accordance with 353A. So it's just wrong, it is in fact wrong.
yes, well, thank you. We will be taking time to consider our judgments. You've given us a great deal to think about. We're very grateful for all the obvious time and effort that's gone into preparing both the written submissions and the oral submissions that we've heard. We will let the parties have draft judgment or judgments in the usual way in advance of handing down to enable typographical errors and obvious glitches to be picked up. We would encourage the parties to agree whatever the appropriate order is that follows from our conclusions. In the event that there's any matter that is not capable of agreement for one reason or another, we will deal with it on short submissions. But so far as taking matters forward today is concerned, we repeat that in the event that the Secretary of State is minded to make an application of the sort Mr. Kovats foreshadowed. We need that by 4 o'clock this afternoon. And similarly, Ms. Nike, if you and or Miss Kilroy separately or together wish to put in a short note in reply to the written material that Mr. Kovats has produced this morning, then by 4 o'clock this afternoon, I hope that will be feasible. Thank you all very much. Oh, hang on.
Can I just say, I don't want to keep anybody hanging around any longer than necessary. Is there a communication I can give to the court, and I communicate with the learned friends, once I've had a chance to take instructions as to whether I will or will not be making the application, because I don't want to keep you hanging on till 4 o'clock.
Yes,
I'll be doing other things.
Yes, no, I don't think anyone will be on tenterhooks quite, but one, Lord Justice Hickinbottom's clerk is the nearest clerk to where we are at the moment, so we'll invite him to come in and give an email address.
Thank you.
That would be helpful.
Yes, that would be very helpful. Thank you very much indeed.
All right.